Hello?
Hi, is that Tom?
It is. Yeah, I'm calling in on the phone. Hi, everybody.
Perfect.
Hi, Tom.
Hi, Tom.
How's everybody doing?
We're doing okay. We're about to get started. We're just going on the live stream, Tom.
Ken, you're all set.
What's
It's
that?
actually, it's Rachel, right?
Oh, Rachel, sorry, Rachel. I'm sorry.
It's okay, John.
You're all set.
No problem. So, good evening. I call to order the Policy Committee meeting of Tuesday, March 1st at 7:01. Our first policy to review this evening is 5131.911, Bullying and Safe School Climate. This policy has been updated per the Shipman and Goodwin Model Policy Full Update of 2021. This policy was last revised in 2015. And it's also a required policy by CABE as per the July 2021 update. The red line changes that you'll see before you as per the Shipman and Goodwin update provide revision to conform with Public Act number 19-166 regarding bullying and safe school climate. The law, which passed 2 years ago, contained various provisions that recently went into effect. Effective July 1st, 2021, the law changes the definition of bullying and school climate, adds new statutory definitions, and expands on the parental notification requirements surrounding verified acts of bullying. Shipman and Goodwin has also revised this policy to reflect a board statutory obligation to post the following on their websites. 1, training materials for school administrators, and 2, a plain language explanation of rights and remedies under Connecticut General Statutes 10.4a and 10.4b. Shipman and Goodwin has also revised this policy in light of Public Act number 21-95, which identifies additional individuals on the School Climate Committee. We did begin our discussion last time on this policy on 118. We had discussion around adding the word promoting in the first sentence. I would like to start our conversation today by first reviewing the purpose of this policy as it is stated in the first paragraph, and then reviewing the new definition of bullying. Would that be okay with the committee? Any comment, feedback? Good? Awesome. Okay. So the purpose of this policy is that the Richfield Board of Education, the board, is committed to creating, promoting, and maintaining an educational environment that is physically, emotionally, and intellectually safe, and thus free from bullying, teen dating violence, harassment, and discrimination. And the board expressly prohibits any form of bullying behavior on school grounds, at a school-sponsored or school-related activity, function, or program, whether on or off school grounds, at a school bus stop, on a school bus, or other vehicle owned, leased, or used by a local or regional board of education, or through the use of an electronic device or an electronic mobile device owned, leased, or used by the board. Further, the definition of bullying has been revised that bullying means an act that is direct or indirect and severe, persistent, or pervasive. Are there any questions, comments, feedback on page 1? Ken?
Yes, I'm sorry, Rachel.
Oh, I'm sorry, Tom.
Go ahead. It's easier to see me.
Go ahead, Tom.
Sure. Question I had is, unfortunately, I didn't get a chance again to read the Public Act, but is that definition of bullying on the bottom of page 1 word for word right out of the Public Act?
Yes, Tom, it is. So that is right out of Public Act number 19-166, and the numbers 1, 2, and 3 following it are also directly word for word from the Public Act.
Okay, the reason I ask is I'm going to study the Public Act one more time, which may answer this question, but when you compare the old version to the new version of the elements of bullying, the elements of bullying now are an act that is direct or indirect and severe, persistent, or pervasive.
Mhm.
Under the prior definition, the requirement of severe, persistent, or pervasive, one of those three, was not required. I think the prior language was just repeated act or repeatedly. So it's a higher burden, it seems. But if that's what the state law provides, it is what it is. But
Tom, I actually find it to be a lower burden because you can do it one time and it be severe, and that's enough. Under the current definition, it doesn't have to be repeated.
Yeah, and that's certainly one way of interpreting it. I agree, but it didn't have to be severe necessarily in the prior version. But now it has to be severe, which is a bit subjective, but it is what it is.
That's an or though. It could be a lot of small things, which would be pervasive,
correct,
or one singular severe thing.
Yeah, if one isolated non-severe, then it probably doesn't meet the definition. The other comment I have,
Yep.
and again, I'm not looking to change the law. I'm just making an observation, but is under the prior definition, it was clear, I thought, that the act was protecting students and applied to students. So students were both the protected party and the directed party. So this, to use criminal lingo, the defendant, so to speak.
Sure.
I don't see similar language in the current version that identifies who is protected and who is directed. I mean, obviously it's implied it's students, I think. But unless I missed it, I didn't see a similar application, so we know for sure that this is directed at students and protects students and doesn't apply to anyone else.
Sure.
So Tom, go ahead.
No, I'm sorry. Dr. Silva, go ahead.
You know, there's actually there's a tool we can use on the Zoom that allows you to mute and unmute us. So maybe that's what we need to do. I'm sorry, Rachel.
No.
So the way in which policies, Tom, are set up is there's a series, and this particular policy is in the series 5000s, which is directed at students. So the top of the policy, for example, says students. So that's how we know, just to answer your question, that it is directed towards that population and no one else.
Okay, so the removal, you know, sometimes when, I'm probably overstating this, the removal of language from a prior statute or law can sometimes be used to interpret the later version of the law. So I was concerned that the removal of the student language might somehow mean that this is to be interpreted differently. But what I'm hearing you say, Dr. De Silva, is it isn't. This applies to students, it protects students, and applies to students, nobody else.
Can I add as well, before, if you look at the two paragraphs preceding the revised bullying definition, it references specifically the environment and the experience for students. So it sets the stage for the context for students prior to defining it.
So I think that answers my question, that the change in the language doesn't necessarily mean that the way it's written now was intended to expand its application.
Correct. I would think that would be correct. Yeah. Great questions.
Okay,
thank you, Tom. Thank you. Anybody else? Ken?
The other person? I did. It was one was a reference to something you said. I don't think CABE can require us to have a policy. They suggest we have policies. I think I wasn't sure if you misspoke or if that was.
Oh, no, sure. So the reason why I used required is, and maybe there's an element here in which you're correct. They post recommendations and then they would post required.
Okay, because like, for example, if
required by state law, maybe that's why.
Right, so the state requires us to have it, not CABE. There are elements on our board that would take exception to CABE dictating the policies we need to have in our district. So,
good point. Excellent point, Ken.
More from that
perspective. Excellent point.
Sean, it's the same with Shipman. They'll have recommended policies and required policies, no different than CABE. And then we obviously adopt the ones that are required, not necessarily required by them, but required by the state or some other affiliation that we have to have.
Right. You didn't call me Sean, did you?
Did I do that?
I think you
Yes,
did.
you did.
Corey, I thought you were my friend. It appears I did. Ken, I'm sorry.
Oh, okay.
Anybody else? Page 1.
Well, I wasn't done.
Oh, I'm sorry. Go ahead.
Or do you have to call Sean now? Is that it?
Go ahead, Ken.
No. So, and this might be to what you were talking about earlier, Dr. De Silva. Where does, like, say, if there was an educator or someone that was bullying or cyberbullying a student, how would that fall?
That would fall under a different series and probably professional responsibilities if it was an educator. Karen, would that be in the two?
Yeah, so the 4,000 series. Yeah,
4,000.
so the 4,000 series is personnel, where it talks about acceptable use for social media. It talks about sexual harassment. It talks about, other types of harassment. So I would think that's where any activity like that would fall under.
And then that would be directed toward, so there would be part of that would have children, to borrow Tom's words, is a protected class. So it's not so much peer-to-peer,
Yes.
but also
It can be like teacher to student or.
I did have a question about, we were specifying that very first paragraph, through the use of an electronic device or an electronic mobile device owned, leased, or used by the board. But I wonder if there's a reason that it's so limited there, when it could be a personal phone, it could be a personal electronic device. It could be anything.
So I think
bring your own device to school.
so. Two things, Ken. So in the regulations, they do define a mobile electronic device. That means any handheld or other portable electronic equipment capable of providing data communication between two or more individuals, including but not limited to text messaging, paging, a personal digital assistant. It also goes into definition of electronic communication, which means any transfer of signs, signals, writing, images, sounds, data, or intelligence. So they do define it in the regulations, but it's not in the.
Yeah, no, I'm just saying in that first paragraph, that last sentence, we're limiting it to devices owned, leased, or used by the board.
So I'm misinterpreting that, Ken, but I'm seeing it or through the use of an electronic device. So stop there. That's my personal one. Or an electronic mobile device owned, leased, or used by the board. So I don't know why they didn't just use one statement.
Yeah, well, why do you have to restate it? An electronic device is an electronic device.
Yeah, I think there's probably a sense of if I use my personal phone to bully you versus using my district provided laptop, perhaps they wanted to distinguish those two different things because neither are okay, where there might be a misinterpretation that because it's my computer, not the district computer, I can type whatever I want and be mean-spirited versus if it's the district owned. So that's probably why there's a distinction. Could you combine those and say through the use of an electronic
device?
Yeah, you could. But my guess is they probably wanted to make the distinction because there's probably a potential misconception that I can bully you if I use my own computer.
I would also take out the mobile device. Why does it have to be mobile? Couldn't it be like a desktop computer that's in the office?
Yeah, it doesn't have to be mobile. I think we can take that out.
I gotta have one end, Dr. De Silva.
If I may, just on that mobile, modifying those little words here and there, we should probably just make sure that's not changing from the statutory language. maybe the statute has some reason why they use the word mobile. I know from search and seizure law that sometimes that distinguishes, that characteristic of a device can matter. It may not here, but we may just want to double check that.
That's a good point, Tom. When we're all through with this policy, I'll have Rebecca take a quick look just to make sure that the spirit of what the policy intended didn't get shifted.
Say goodnight real quick.
Good night. Oh, good night.
Okay, bye. Love you.
Time for bed, Oliver, 7:16.
I know. He's late. Lights on,
Yeah,
7:30.
it's early. It's early. You got a lot of party time in ya.
Something. Oh, go ahead, Ken.
Oh no, I was gonna say I'm good with page 1.
Okay. Just something I wanted to bring up. So in the third paragraph down, it does say students who engage in bullying behavior or teen dating violence shall be subject to school discipline. We do have a student discipline policy, 5114. I checked it out today, so we will have to update it just to reflect the definition, the new definition of bullying. But that would be the only definition to be updated in that policy. So just want to make everyone aware. Okay. So page 2. You'll notice the definitions of cyberbullying, teen dating violence, they have not changed. I just wanted to also note for policy committee members that we also have a policy on cyberbullying. It's 5131.913 for your reference, and it does match the definition that's listed here. So no changes are made, just wanted to bring it to everyone's attention. The list that starts on page 2 with number 1 and it goes to page 4 with 18, those are all directly, that's the exact language that's taken from Public Act 19-166. So just so everyone knows. Any questions on page 2? Ken?
Why is it called teen dating violence? Couldn't it be between a 20-year-old student and a teen student?
Let's see. I'm going to say probably because going back to what Dr. De Silva said about this being a student series. So that probably has to do with that, but I think that's an excellent question.
I think we do have children in our students in our district who are not teenagers.
That's an excellent question. Why is it just not dating violence, and why is it teen dating violence? Okay. Excellent question.
I'm curious, Rachel, if that is connected with the way in which it's defined.
Yeah, I do believe teen
the
dating
law.
violence is a language in the statutes.
And
At least
it's defined on the
historically.
next page. Yep.
Mhm.
Yeah.
So I think the definition opens it up. So if someone's a student, that would fall under that. They would fall under that.
They get a good lawyer. Gotta watch those lawyers, right, Tom?
Any other questions on page 2?
No, but that's good lawyering there, though, Ken, I have to say. But I suspect it's part of the statute.
Probably.
The definitions do fall, to Dr. Hanaway's point, they do fall directly from Public Act 19-166. So I had a question on number 3. It says, require school employees who witness acts of bullying or receive reports of bullying to orally notify the Safe School Climate Specialist. Maybe just for us, and I believe I know who they are, but who are our Safe School Climate Specialists, and how are teachers and staff made aware of this policy?
Well, so at the building level, it's a school principal, as the pride said, because here it says comma or school administrator, and we have always functioned as the school administrator because they run the Safe School Climate Committees at the building level. So we didn't want any confusion in terms of where the reporting should go, and that's how it's functioned in Ridgefield is that the principal, and if the principal's not physically available, the assistant principal or the supervisor plays that role at the school level.
Great. Thank you, Dr. Hanaway.
Rachel,
And
was the second part of your question?
How are teachers and staff made aware of this policy? So if bullying goes on, how do they know what action steps to take?
That's done at the school level as well. But as you indicated, Rachel, when we began, there are some changes, and we'll get to them later, that will require some additional training materials. The the inclusivity of the committee, which I think we've talked about briefly, but we'll talk about again. That's a change from this year, that we engage the union in that part of it. But it is a part of the process that will have to just be communicated a little bit differently at the start of next year.
And at the beginning of each year, we group together mandated trainings that happen from the building administrators to the school staff. One being mandated reporting, but reporting of bullying also happens at that time, at the beginning of this that few day period before students return, the beginning of the year every year.
Thank you so much.
I just wanted some clarity on that, on what we're talking about. So is the school administrator the designated safe school climate specialist?
For the building, yes.
Okay. That's their title or whatever.
Yeah.
Yes.
A hat. I'm sorry, that's a hat that they wear. Okay.
And then the district one, Corey wears.
Okay.
Put it on. There you go.
Perfect. Thank you.
So Ms. Gillette would be then, because that falls to a later question of mine. In the paragraph here, it says, consistent with the requirements under state law, the board authorizes the superintendent or designee. So so it would be designee would be Ms. Gillette.
Miss Gillette is the district safe school.
That's me.
Thank you.
So many hats. So many hats.
So few people, so many hats.
Yeah.
Any other questions? Page 3. So now on page 3, number 8, there is a change as per the Shipman and Goodwin red lines here to reflect a board's statutory obligation. We already in here say that we require each school to notify the parents or guardians of students who commit any verified acts of bullying, and the parents or guardians of students against whom such acts were directed not later than 48 hours of the completion of investigation. Then it adds in here, A, of the results of such investigation, and B, verbally or by electronic mail, if such parents or guardians' email addresses are known, that such parents or guardians may refer to the plain language explanation of the rights and remedies available under Connecticut General Statutes. Are there any questions on this page? Okay, on page 4. So again, this language is directly from Public Act number 19-166. I just wanted to point out a couple of things on this page. So there's some definitions that are in the regulations just for committee reference. So like school sponsored, that's a definition in the regulations, hostile environment, electronic mobile device, and school climate plan. Are there any questions on page 4? Okay. On page 5, there is an add-in at the end. This is also per Shipman and Goodwin revised language.
I'm
this
sorry, can I
I'm
just
sorry.
go back to, can I just go back to page 4 just because to Tom's earlier point about the
Absolutely.
mobile device. This is where we just want to be sure, I guess, going back to the earlier point is here it's called electronic mobile device owned, or it's described as an electronic device or an electronic mobile device owned leased. So if that language is also in a regulation, we just want to be sure that it lines up if we make any changes.
Absolutely.
But something like that, can't we make it more broad?
We can. We would just
Like
want
by
to
removing mobile.
Hmm?
So that would be the question.
Say it again, Ken.
That would be the question, just making it more broad. I mean, I think under, aren't we allowed to make something more prescriptive or more restrictive?
We can. So my point was if there wasn't any reason why it's defined that way, then we just need to be sure that it's matched up to the regulation too.
And so then on page 5, that new paragraph, it's about the training materials to be posted on our website. I wanted to go back to the point before when I brought up about that the board authorizes a superintendent or designee, which would be Ms. Gillette. In the first sentence here, it says, as required by state law, the board, after consultation with Connecticut Department of Education and the Connecticut Social and Emotional Learning and School Climate Advisory Collaborative shall, and then it's about the training materials. So I just want to be clear, the board there means Ms. Gillette?
So yes, when they, not necessarily Ms. Gillette, but when they describe the board here, they mean the administration.
Okay. Thank you.
So why doesn't it say the administration?
Or district? We've seen this in other policies too.
I know.
I think, and you probably asked the same question, Ken, but when they refer to board, that's sometimes the administration, sometimes it's the district. But what that really means is that, ultimately, the website is the board's website.
Yeah. And I just think to note, Rachel, maybe for the full board discussion, that the paragraph added in on page 5 is essentially the paragraph from page 4. When somebody asked why it was removed, it wasn't removed, it was just moved.
On page 4.
It might come up.
Oh yes, the training materials. Yes.
Yeah, 19 was that. The bulk of that was from there.
Okay. Good point, Ken. Any other questions before moving on? Okay, so I think we have a couple of questions whether or not we can change teen dating. I don't think we can because it is in the public act as defined as that. But that was a question, and then also on the mobile device.
Yeah, so I'm just going back to and I'm assuming you all have a copy of the definitions that where they talk about mobile electronic device. I think Ken's earlier question about why mobile, and they describe it there. I mean, I guess you could probably do any of those things on a desktop, but I don't know how you take out the word mobile without changing that definition. You know what I'm saying? So they have on page 8, they have mobile electronic device means, and then they go through it. But it's as much as it says mobile, it doesn't really mean it could be anything. It says including but not limited to a text messaging device, right? That you can do from a computer. Yep. I don't think any kid knows what a paging device is, but let's pretend. A personal digit assistant, a laptop computer. I mean, it doesn't talk about a desktop per se.
Right. So then the counter to that would be, then why doesn't it say through the use of an electronic mobile device or an electronic mobile device owned by the district? It's making its own distinction. And I'm going back to that first paragraph.
Right. There are actually two things. I think the first question, there's the electronic device or electronic device owned, leased, or used by the board.
Right.
Actually, even not used by the board, going back to page 1.
Yep.
Or through the use of an electronic device or an electronic mobile device owned, leased, or used by the board. I don't know what used by the board means there. So I do have a question around that. But then the second, earlier, Ken, you asked if we could just cross out the word mobile. And then that's when Tom brought up whether or not that would change the spirit of this statutory language at all. And so I think there's two pieces there. The way in which they define mobile on page 8 is one question, because if we were to just take out that word mobile, then it no longer defines it later. Do you understand what I mean?
Yeah. Then maybe I would just throw mobile into the first electronic device then, because we're not defining an electronic device.
Correct.
And I think used by the board could mean a personal device. So if an administrator if a student grabs an administrator's personal phone and uses it, I mean, that's a stretch, but that would be covered by used by the board.
Yeah, they use it again in the language on page 8. And that, again, we could shift the recommended language if we want to make it make sense for us, for sure, but the used by the board is just an interesting, I don't know, it's just
Yeah,
an
that's interesting
way to. Because it's not that this isn't for the adults, this is for kids, this policy, so it's just an odd.
That's what I mean. So they'd have to take an administrator's personal device and use it.
Mm-hmm.
Yeah.
To fit that definition.
Yeah. I agree with Ken.
Okay.
Yeah. Okay. Okay. So I think this could go forward to the full board for a first read with those questions being answered at our full board meeting. Right?
Is the same? Do we have to go through these climate plan though? Isn't that part of the same?
So the Safe School Climate Plan, I believe, is the regulations to this policy.
I see.
So,
okay. I see.
Yeah.
Though helpful, Ken, just going back to that teen dating. So they define teen dating violence. I think it was Dr. Henry or Rachel may have mentioned about students. It means any act of physical, emotional, or sexual abuse, et cetera, that occurs between two students who are currently in or have been receiving or have been recently in a dating relationship. So the two students would capture anyone who's a student RPS, which would include, to your earlier point, someone that's not necessarily a teen, right? It could be.
Oh, I understand. My point was a good lawyer would latch onto that teen dating language and say that didn't apply to their client who wasn't a teen. I'm just saying. Those things happen. I don't know why, but why even in the statute do they have to say teen? That's, I mean, I know that's not our problem, but just dating violence covers it all.
Yeah,
so.
I think probably because it becomes criminal after that.
Mm-hmm.
You know, that would be my guess, Ken.
Oh, that makes sense.
Makes sense.
But then maybe that should be part of this though, because we have the potential for it to be a criminal act.
But we have mandated reporter requirements that would also complicate this,
Right.
You know, in terms of what our obligations are, is distinct from bullying, distinct from criminal, distinct from potential abuse.
They all overlap.
Great.
Can I ask a question?
Go ahead, Mr. Wynn.
Okay, so you mentioned that corresponding language changes needed to occur in the student discipline policy.
Yes.
Does it make sense to move that forward with this policy at the same time before the board so they happen in tandem?
Are we okay with that? I know it's not before us this evening. That's an excellent question, Ms. Doing. I know it's not before us this evening, but do policy committee members feel comfortable if for a first read, we do the first read at the same time with this policy and just updating the language for bullying and student discipline?
So
in policy 5114, It's a policy student discipline. I think it was just revised actually this fall. And we want to reflect the definitional change of bullying in number 32 in the list. So if we bring that, to Ms. Dewing's point, at the same time to the board for a first read, even though it's not in front of us here right now this evening, would policy committee members be comfortable with that?
I think so, because it was this board that approved that.
Yes, correct.
This board already approved that that policy, so that I think, yes, this is just a change in language of an already approved policy by this board. So it's not, there's nothing.
Correct.
I think I'm okay with it.
Okay. Okay. So then I think we're going to go on then. Isn't anyone have anything else for bullying, or we can go on? Okay. So the next policy up for discussion is health assessments and oral health assessments, 5141.3. I definitely want to ensure clear communication around this policy, and that is why there's no other policies on the agenda for this evening. I also want to be mindful and respectful of comments made by all Board of Education members during our discussion on 214. With that, I would like to propose that I lead us through the purpose of the policy and sections 1 through 6. And when we get to section 7, we could recap comments made and have a discussion on how to move forward. How does that sound? Is everyone okay with that?
Yeah, sure.
Good? Okay. So, health assessments. So this is health assessment, screening, and oral health assessments, policy 5141.3. The purpose of this policy, as stated in the first paragraph, is the Ridgefield Board of Education, the board, requires each student enrolled in the Ridgefield Public Schools, the district, to undergo health assessments as mandated by state law. The purpose of such health assessments shall be to ascertain whether a student has any physical disability tending to prevent the student from receiving the full benefit of schoolwork, and to ascertain whether schoolwork should be modified in order to prevent injury to the student or to secure a suitable program of education for the student. So in reviewing the next few sections, what I thought would be helpful is looking at the actual, this is the health assessment record, and it's found on our RPS homepage. And if you look at it, this is what, you know, as a family, you would bring to your family doctor when you take your child for a physical. So part 1 is to be completed at home by parent or guardian. Part 2 of this says medical evaluation. Healthcare provider must complete and sign the medical evaluation and physical examination. Part 2 of our policy says health assessments required. Prior to enrollment in the district, each student must undergo a health assessment, which shall include. So this covers part 2 of our health assessment policy. Also in part 2 of our health assessment policy, it says an updating of immunizations as required by state law. Part 4, I should have put this up on the screen, but part 4 is immunization record. We do have also another policy that covers immunizations. Part 3 of our policy in front of us is oral health assessments. Part 3 of the health assessment record is oral health assessment and screening. This is to be completed and signed by a dentist, a health practitioner. It says here, the oral health assessment identified in subsection A above shall include a dental examination by a dentist or visual screening, risk assessment for oral health conditions by a dental hygienist, legally qualified practitioner of medicine, physician assistant, or advanced practice registered nurse. So hopefully that was just helpful in clarifying purpose in coordination with the health assessment record form, which can be found on the RPS homepage. Part 4 of our policy is about screenings required. It goes over vision, hearing, scoliosis. Part 5 goes over assessment screening results. The results of each assessment and screening required or requested by this policy shall be recorded on forms supplied by the State Board of Education. So right on top of the form here, State of Connecticut Department of Education. Also on section 5, there was an update as per Public Act number 21-121. And it goes into that the district shall report to the local health department and Department of Public Health on a triennial basis the total number of children per school and on a district-wide basis having a diagnosis of asthma. Part 6 is about exemption, that nothing in this policy shall be construed to require any student to undergo a physical or medical examination or treatment or be compelled to receive medical instruction if there is an objection on religious grounds. So the next section, section 7, other non-emergency invasive physical examinations and screenings. So this section policy definitely caused the most concern. It was discussed with the full board on 214 that this subsection is written with the spirit of the Protection of Pupil Rights Amendment. That is, that it affords parents of students certain rights regarding, among other things, participation in surveys, the collection and use of information for marketing purposes, and certain physical exams. So at this time, I would like to open it up for discussion, being mindful and respectful again of the comments made on 214. So who would like to begin? I could add more, but I don't want to hog up the time. So.
Yeah, no, I think that's helpful to walk through. I'm presuming that was practice for the full board.
Sure, I could do that for the full board as well.
So that I think that will be helpful, but I don't think it addresses the big concern of the community. I'll just say the board and the community, and that they're unless that's changed since then. I think the big question was what exactly is a non-emergency invasive physical examination, and how is it defined? And if it's not required by state law, why are we even doing it? And so I think those were sort of the questions.
I agree with you, Ken. I think some of the comments that evolved were about the genesis, providing it in layman terms so that the community could pick it up, understand it, that it was alarming, and that the extra protection that was added in the language on 214 made it more comfortable. So I did do more research on PPRA, and I do have some information to share on the genesis of PPRA and the wording, including here. I went back through each amendment to PPRA as the law passed. Would that be helpful for committee if I went through that?
Only if it answers that question. Like, what is a non-emergency invasive procedure, and if it's not required by state law, why would a school be doing it? I think those are the two questions. Like how it got there, very, very similar to some of the disingenuous arguments of, well, the prior board passed it, but other members of that board, absolving themselves of any, I don't know. I didn't look at it. Whatever that is, it's the same thing. So the genesis of it would be one thing, but why was that language even originally in it, in like that first iteration? And what is it? So far, we haven't been able to find a definition of what a non-emergency invasive procedure is.
Sure. I think I could go through it. Selena, I'm sorry, I just saw your hand. Did you want to say something?
Well, I
have a
think,
bad memory.
and I'm having trouble with my printer, so I was trying to print all this stuff out, so bear with me. But I'm wondering, and I could be wrong, but if these policies are the reason we're having trouble is because they're supposed to be like read in tandem. So I think the law states that children have to have these screenings, right? And if they can't afford them, then perhaps we're supposed to be able to provide them. And maybe that's where the confusion comes in. I'm not sure, but I'm thinking, so in order for a child to attend school, they're supposed to have, specific, health situations taken care of. And so maybe the reason we're confused is because these policies they go together.
No, I think the confusion, Selena, comes from the fact that it says that are not required by state law. So
well, it's not required for the. Well, I see what you're saying.
That's just the language in the policy.
So,
And so we don't even know what that is, and two, it's not whatever it is, it's not required by state law.
so if I may, let me just throw this out there, and if it is helpful, great, and if it's not, I hope it doesn't add another layer of confusion. But let me just throw this out there. So in 1974, PPRA was originally enacted, and it provided parents rights to access instructional materials that were designed to explore or develop new or unproven teaching methods or techniques. In 1978, parent consent was added before obtaining information such as political affiliations, mental and psychological problems, sex behavior and attitudes, illegal, antisocial, self-incriminating and demeaning behavior, critical appraisals of other individuals with whom respondents have close family relationships, legally recognized relationships, and income. In 1994, the amendments to PPRA broadened consent requirements. So educational agencies and institutions shall give parents and students effective notice of their rights under this section. And then there was enforcement. The secretary shall take such action as the secretary. There was an office and review board to investigate, process, and review violations of the rights established under that section. From what I found, and I did not pass this through council, under President Bush in January 2002, the No Child Left Behind Act was passed. In a section at the end of the act entitled Repeals, Redesignations, and Amendments to Other Statutes, an update to PPR was passed. It added opt-out requirements, limited ability to collect information for commercial purposes and for certain physical exams, and also provided parents with access rights to instructional materials, surveys, evaluations. So that's kind of the genesis of it. From everything I read, it doesn't seem like there was a one particular circumstance, but only to try to continually protect the rights of parents and to notify them, if anything, since they are responsible for the welfare of their children. So I do hope that that was helpful on some level. Thank you, Ken.
It really was interesting, but it didn't get to the crux of the two questions.
So, Ken, I think at least what I took away at the end of December 14th, at least from some of our board members, was that there was still, you're right, that there was still a concern around this language being there. And in fact, I think at some point someone said, why can't we just say that we will follow all of the rules associated, and I'm paraphrasing, but associated with PPRA. And because I think that all of that language made folks uncomfortable, especially because we couldn't define an example. Mm-hmm. But I feel like I just want to take a moment to remind us that the spirit of this is not to protect the district, in my opinion, but rather to protect students and parents from the district or, a district, making decisions around particular screenings or physical examinations in which they did not receive parental consent. And so despite that, I still think that people didn't feel comfortable because and I am overgeneralizing perhaps, but when you read and someone can't say what would be an example of that, and even our attorney at that meeting was saying, we can't think of an example of this, right? Our medical advisor couldn't really, no, we all couldn't, because it's not something that we would do. But
Right.
it protects parents and kids from anyone ever doing that without parental permission. And, certainly we could look at the language and see if there's a way that we could be more restrictive, or I don't think we could be clearer, Ken, about an example when there isn't one. I think in many ways it's this fictitious thing that could possibly happen in the future that we don't know.
Right, but that to me, that's akin to saying in the event of an alien abduction, this is who you notify. These are the three people that have to notify within 48 hours. These two people have to write a report. And if we could define what an alien abduction would be. We can't define what an invasive non-emergency invasive. What can we get from Rebecca? Maybe what if we just deleted section 7? Section 7 is what's causing. We
section 7 is section 7, and Rachel clearly has done a lot of research.
Oh my gosh, so much.
Section 7 is the piece in which is connected to PPRA and our funding, if we were to receive federal funding. Right. And it's, again, my fear in not having that there is that then our students' privacy and or parents' decision-making in a process isn't there. In absence of having something, could then something be done differently? And so, I'm not opposed to looking at section B, and maybe there's a reference there that is references according to PPRA. I don't know, but I think it's important that we have something in writing that alerts families that we don't have the right just to do things without asking your permission.
Dr. De Silva, to Ken's question, and I agree. I think we needed to notify parents and to make them aware of their rights. But if we deleted this section 7 here, we now have this same section in our student privacy policy, which we just amended yesterday with this exact same language. So perhaps clarity for families could be that now you're reading this non-emergency invasive physical examinations and screenings in the student privacy policy, which is as per PPRA, and therefore it makes it more clear when you're reading.
That's a good point. That's a good point, Rachel. And I could certainly ask counsel whether or not could we, like Ken suggested and you're suggesting, remove section 7 out of the health assessments, because it's not really a health assessment, but it is part of student privacy, of which we have a policy and we just approved that last night that reflects the same language. I think that's what you're asking.
Yes, correct.
Because I think what perhaps people are responding to is that it feels like this is a thing we do because it's part of this, as you're saying it now, I'm wondering, is that are people responding to this in an adverse way because it's not necessarily connected to the student privacy policy? Well, it is, but that's not where we've now placed it in a secondary place. I would just need to know for sure and feel comfortable for sure that we can remove it out of this particular policy, which my guess Rachel, as we could, because I didn't see anything in PPRA that says that it must be a part of the health assessment and oral examination policy, but rather that the district just had to have a policy. And if we have one related to student privacy and it's there, then that may just be good enough.
Correct. And it could have been that because prior to this last November, when the full board had the first read on the student privacy policy, it was a new policy to RPS, but wasn't a new policy, so to speak. So now that we have that, again, it could create more clarity. And, as I think about it even further, I went through the health assessment record, right? That's really the spirit of the health assessment and oral health assessment policy. So I do think it could be really helpful.
I think when we bring it back before the board, I think it would be helpful to bring that policy that we just approved also, just so people are looking at them side by side.
Yeah. Agreed.
Back.
Agreed.
If for some reason council thinks that needs to remain, can we generalize it as you were referring to earlier, Dr. De Silva, of Richfield will follow the PPRA,
Right. So we could, so my suggestion would be that if council says that it must be within this policy also, that with all due respect, I would bring it back to committee before bringing it back to the board,
Right.
even if it's just
Yes.
for a minute,
Yes.
that language,
Of course.
just to make sure that this committee is comfortable with that. If between now and our next meeting, Rachel, if council says, yes, it's perfectly fine to just be in the student privacy policy, then I think we could just go back to the board and if that policy has already been approved. And so certainly just talk through what the committee has, where the committee has landed, and hopefully both families and the board is comfortable with that position.
I was making more reference to saving a call to Rebecca. If she says it has to be in here, can it be in here generalized? Or does it have to be this level of detail?
No, you're right. I think that's a secondary question, but my guess is it probably doesn't have to be, because as long as there's reference to the PPRA, even if we named a section, right?
Sure.
The
Right,
section.
exactly. Yeah, as specific as possible.
I mean, it's honestly, it's stealing from Peter and paying Paul, because it's basically.
Well, it's fine, but then people can object to PPRA, and then they can go holler at those people rather than hollering at RPS.
Or at minimum, at minimum, they could also, they'll have the PPRA, so maybe they'll understand the spirit in which it's there. So that might be helpful both ways.
Yep, exactly.
Yep. Great. Okay, I think that was a very
great idea, Rachel. I want to.
Ken, you had the idea first.
Well,
this was a team effort.
You did all the research, so I think that's great. No, but I mean, and then referencing back to the student privacy policy, that's the stroke that makes it doable.
Thank you. Well, great teamwork, guys. Anything else this evening? Questions, comments? Okay, so do I have a motion to adjourn?
I so move.
Ken, second? Selena, thank you everyone and have a